So I'm going to start. So the question I think I wanted to start with is, so why did the planning board make this settlement agreement? And you can see some reasons here. So first of all, for many of you came out to the sessions of the public hearing, you may know that the board was split on the original decision, but I can tell you that we did all unanimously feel this was in the best interest of the town, mostly to protect, have some control. So the first thing to note is that given the way that the land court works, the information that was presented during the public hearings is not the only information that goes to the appeals court. Once you have an appeal, either side, the applicant or the town, can present new information and create a whole new case if that's what they so desire. And so that was, I think, one of the things that drove the reason for us to consider this. And then as you can see up here, mostly we think it was in the best interest of the town really to allow some controls over some of the key points that we'll see here tonight. So with that, I'm going to jump into, we're going to go through each of the key points in more detail, but first we'll start with just a summary of the key points. I'm not sure if you've had a chance to read the document in detail, but these are some of the key points we felt that were in there. So the first and foremost is that all non-residential traffic be from the Hudson side access, the new road that would be built. I know based on the input at the public hearing, this was probably one of the biggest concerns, and we felt that getting this was a big plus in general, ongoing. Second point here is that there still will be large events, but there is a cap and a limit on that, as well as limits on what those can and cannot be. That includes limits of pyrotechnics and noise. The next bullet is really around, this doesn't mean that the applicant can never apply for anything for that piece of property. This has to do with this use, the whole Dover discussion. That's what this bullet is referring to. And then the next bullet is really around maintaining a lot of the site plan. There weren't any conditions, but the site plan submitted and all of the original bylaws that it was going to follow would be able to be maintained. If this were to get decided for the applicant in the land court, essentially the planning board and the town may have lost control of all of those things, as well, including the access from the Hudson side. And so overall, I would say in consultation with both town council, the board of selectmen, and all of the planning board members, we did feel that based on all the information that these things would protect the town's interest and were in our best interest. All right. There's some key definitions that we're going to start with. I'm not going to read this, but I'm going to just, we'll go through them and I'll just call them out and give you a chance to take a look. There's a definition of major event, noise generating, pyrotechnics, and so I'll give that a moment. And there's a second page of definitions as well that we'll go through. gunfire and noise specifications. And again, we put these definitions in because they are things that get referenced in the settlement, and therefore, as we go through, we take a deep dive into each of those key points. Just wanted to make sure that we're all grounded in talking about the same, referring to the same thing. All right, so with that, we'll take a deep dive on each of the key points. So first is traffic. Essentially, what's in the agreement is that all museum and commercial traffic, so basically non-residential traffic, will in the future will go through the Hudson side access, the new road that will be built. This includes all website, advertising, signage, marketing communications about museum, about the events, will reference that address and not the Barton Road address. And then the idea is that for the construction traffic to be allowed on Barton Road to a limited extent. So you'll see in later slides that we really plan on having the road as part of the phase one so that the majority of construction traffic can go through the Hudson access, but clearly we need to start, if the project starts and the Hudson Road doesn't exist yet, there needs to be a way to start construction. So that's, again, it's meant to be limited and it specifically calls out that the road itself should be constructed first, in the first phase, to limit construction traffic. And I believe we even have it referenced, and someone correct me if I'm incorrect, but not to go over the dam. So even for the limited amount of construction traffic that needs to go over Barton, to not use the dam side. And again, with the idea that once the Hudson access road is built, that basically it all goes from that side. So this slide goes through some allowed uses. So I do want to say, even though if you customary museum accessory uses being some corporate outings, weddings, those are not meant to be outdoors. You know, things that happen there today, but inside, that was the intent. We look at, okay. This is just a continuation of allowed uses in events. So this has to do with exhibitions and demonstrations that are not part of the major events that you saw the definition for. These would be potentially outside, but would be limited to the number that you can see here, 2 per month for the 6 months of the season. They would prohibit gunfire and pyrotechnics, and they would put a maximum on the number of vehicles that could be used in any one. And then there are some noise specifications in the settlement that any of these would have to follow. Yes?
Is there any definition of the number of days involved either in the major event or in these events? Are these 2-day events?
Right, sure. So hi, I'm Barbara Huggins Carboni, Huggins and Witten Town Council. And to answer Lori's question, the limitation doesn't appear in the definitions. I think Lori's suggestion of a reasonableness standard makes sense, also just based on the board's knowledge of prior activities and what those entailed. I mean, I think those were probably built into the understanding of what was what's intended in the agreement.
And to add to that, the events that have gone on up to now have been events involving reenactors who are involved like for a weekend kind of activity. So I think from their perspective, it would be impractical for them to have a reenactment or an event that would go longer than a weekend anyway.
So I do want to specify, the events you're talking about are the major events?
The major
These are
events.
not the major events.
Okay. So are you referring to the non-major events?
That's what this refers to.
Again, I think they're of a nature of a weekend kind of activity. Again, given past performance, the people that are attending and their time constraints and coming from out of town, I think it would be very unlikely that an event of that nature would, go into like a full week.
I think there may be some disconnect. Right now, we're still talking about the minor events, and I don't think there's any understanding or room for those to be multi-day events, because the multi-day events are the major events. So a minor event would be a day event.
So the question was, is that spelled out? And I think, Barbara, do you?
It doesn't appear in the definition. I have no problem, if need be, defending that in any discussion with Mr. Collings or the Collings Foundation or with the board. I think it was understood what the distinction was between the major events and the minor events. And maybe we can discuss this a little bit more, maybe if the chair wants to move on to some other topics, and then I'd be happy to return to it later.
All right, so on to the major events. Again, 4 public display demonstration events allowed per calendar year. 2 of those events could use pyrotechnics. 1 is pre-World War I, and 1 is World War II era or later. Gunfire is allowed. All major events can be noise generating, so as previous slide was that it has to comply with the noise specifications in the settlement. These are the, I guess, anomalies that are specifically called out.
I'm just going to do this the orderly way.
Are there any time constraints? In other words, is there a time before which they cannot start this kind of noise generation and when they must stop?
We did not specify. We can follow that up when we get to the detailed Q&A, back to the number of days, times, etc. All right. So really, the question is, what can you expect? So the building inspector has issued a temporary building permit for road construction and for construction to begin. So temporary is because the agreement, while signed by both sides, has not been formally accepted by the court yet. And therefore, that's what the temporary is. And once the agreement is formally accepted, I believe there can be a non-temporary building permit. And the temporary nature, we do believe, again, it's in the town's interest to build the Hudson Road access as soon as possible. So if you're wondering why temporary would be issued, I think that's one of the key reasons. And again, just keeping with that theme, it is my understanding that the Collings Foundation intends to complete the road by this fall. And again, the road is set to be part of Phase 1, and once constructed, all construction related, and then all, as well as commercial, non-residential use would be from that side.
Excuse me, question on that. There's a lot of use of intended and intention, the words. And so when we're talking about an agreed court settlement, there's a lot more to do with words than intention. So is this construction for for everything but the road dependent on the road being constructed first? Or is this construction intended to happen with the intended belief, or whatever you want to say, that the road will be constructed first and then afterwards or during? I'm just trying to find out the order of things. Is the road going to happen first?
Yeah, that's a very good question. So the building permit that was issued specifies that the road construction is first, and that's why it's a temporary building permit. It's another reason it's a temporary building permit. After the agreement is accepted by the court, then a full building permit can issue. But it's a condition in the permit, in the building permit issued by the building inspector. So.
Go here and then up front.
All right, so what are the restrictions on the current heavy trucking on Barton Road, which I believe was not going to occur if we approved the access road, which we supported, and now the trucks are rolling by the house starting before 7 a.m. every morning. So when can we expect the trucks to stop?
You want me to try to feel this? So, so the typical construction hours are, for most projects in town have been 7 to 5:30. I've also fielded similar complaints and calls. So one of the other things that came up was, there were trucks that were going across the dam. We've been getting up to speed now that construction has started, and we have the police department working with the construction team to get some signs up, both just after the Barton Road entrance and at the Barton Road, Sudbury Road area, just to make sure that all the folks who are out there in trucks realize where they can and can't go. But to speak more directly to your question, there is the reality that they are building a crossing, a stream crossing, to get that road across, and they do need to go on Barton Road. So there was some. That's a separate question. Yeah, yeah. I think the expectation is that they should, and that's something we would talk with the building inspector with and make sure that that's being stayed on top of. But otherwise, I mean, the purpose though is to get them, to get everything mobilized and the equipment in, and it's kind of the nature of it. But I hear your complaint, and like I said, I've fielded a couple, and I'll be talking with the building inspector again. Go up front.
I just have a question about, you keep referring to the temporary building permit. How far is construction supposed to be? Because you have up here surveyors are currently flagging bounds. They already flagged them and the trees are down. All the trees are gone.
I mean, those are activities, that are allowed, property owner is allowed to do regardless of whether there's, other construction or a project such as this. So it isn't that that they can't do anything on their property until they build the road. I mean, the building permit says build the road first, but sort of active construction on the, on the museum can't proceed until the road is constructed. What? Yep. Well, temporary, I mean, in this case, it means it's issued and on a particular date, and it expires on a particular date, because we did not want to have a building permit issued open-ended when this thing had not yet been approved by the court. So, and the reason to issue it was issue the building permit with these conditions, the temporary one, was because it's in the town's interest to have this road, construction on this road started, so that the access for the rest of the construction can proceed via Hudson. Does that answer your question? Okay, thank you.
Hi, I was just wondering why it wasn't possible to start construction on the access road on the Hudson side, or Main Street side, and work its way in, instead of coming across Barton Road. Because it is a problem.
Well, I'm gonna repeat myself because I think this is a similar question. You know, there is a stream crossing. They need to mobilize from both sides. There is a lot of equipment that needs to go on both sides there. So I'm not surprised that there's action right at the moment coming onto Barton Road, but yet the Hudson access is absolutely a part of getting that road built. I mean, that's going to be, there's going to be a lot of action there as well. So I think this is the nature of the scale and the type of the project. And it's not ideal, but it's the reality right now, especially at this beginning stage.
I think some of the concerns that we've had about the quantity and speed of the trucks going up were on Hunter Ave right before it turns into Barton. The corners that they come flying around, the stopping and herky-jerking around to try to get around poles. It feels like the project should take some responsibility for informing their crews coming in and the trucks of the neighborhood nature of our neighborhood, and perhaps that could be reinforced.
And I think to Jesse's point earlier, that is definitely, thanks for bringing it up, and it's definitely something we can discuss with the building inspector.
Do we have an estimate of how long the construction is supposed to take place on the museum itself and when the museum will be expected to be open?
I'm I'm really not the best person to speak to it. Bob, you may have a better clue than I do. Otherwise, I'm going to take a guess at the construction schedule.
The agreement we have with Hudson specifically limits construction on the road to 90 days. It's our intention to get the road completed over the wetlands area into Stowe in the 90 days and in time for the October event. That's our goal.
So the question was about the museum.
Oh, the question is the total time? It's a little hard to judge because we'll be working in the winter time, but our goal is to be about a year from now.
I'm not sure how useful this is, but we have these in case we want to refer to them and people can come up. So, sorry. I'm not sure how useful these are, but we have a few enlarged slides that we can refer to as questions arise. But essentially that was all we had prepared. I think we can certainly continue with Q&A at this point.
So my question is about the Barton Road access. I'm wondering, once the Hudson Road is complete, what steps will the Collings Foundation take to block that off so that, will there be, you know, a gate across that access?
We did not require a gate. I mean, those access points are still open for residential use, and I do want to remind people it is residential use as well as accessory to residential. So if there are, just like you or I would have a UPS delivery or an oil truck for our house, that can still use those roads, but that all commercial and construction would go from the other side, with the expectation being that all advertising, all communications about how to get to the Collings Foundation would have the other address, as well as when there are events that there would be signage, and we even talked about, correct me if I'm wrong, even police detail, but basically ways to just, you know, inform people not to go the Barton Road access. So I don't know if I've missed anything. Jesse, if you can think of anything.
What is tank pickup and delivery constituted as? Will it continue to go on Barton Road? Because that's a major
You mean
concern for the
the actual tanks
neighbors.
for the museum?
Yeah, he takes them to
Yeah, that would be
events.
commercial use.
Okay.
So when I say residential, it's basically like you think of it as you or I going to our houses and whatever utilities, deliveries that might come to our house, but anything associated with museum business, deliveries for the museum, that is expected to go on the Hudson Road access. To start as soon as the road is finished.
I noticed that the definition under gunfire talked about explosions used to launch projectiles. And so it's my impression that if no projectile is being launched, i.e. shooting blanks, then that noise doesn't fall under that definition and is therefore not at all regulated anyhow anyway.
I guess, Barbara, I'm going to ask you to. We talked about this.
Yeah, I mean, I think I understand what you're saying, but I don't see that definition as allowing for unregulated noise. I think it's, yeah.
I think what he's asking is if they're not actually firing a real projectile, is it not covered by the definition?
I don't think so. It's a loud noise generated by a device when an explosive charge is used. I don't think that means it's limited to when the explosion is, when a projectile is actually launched. I think that includes the noise that is made. So the noise that's made, whether a projectile is issued or not.
When we say pyrotechnics, that's just an uncontrolled explosion, makes a lot of noise. It's also prohibited from using cannons, except for on the two events which we allow the pyrotechnics and cannon fire. But other times, the cannons fire, that means something on wheels can't be used. His tanks can't fire their blank shots, can't make all that noise. You can't set off explosions, so he's limited to that. Just a gunfire from a normal rifle or whatever with blanks in it. Shotgun, that's probably about the biggest you're going to get is a shotgun.
I have a question that I actually hadn't given much thought to except for a previous question regarding the current road that is being currently used for the construction vehicles, and that's completely understood. For residential use only in the future, that road actually, like they have, the Collings Foundation has I shouldn't say the Collings Foundation, Bob and Caroline have a road to their home that has always been there since I moved in 13 years ago. And so the road that we're referring to, that is being referred to, is actually further away. It's where a lot of the parking for the events on one end is where the cars would park for the events. There may be a museum there now. I forget the layout. But it's well away from the home. And so I don't know if this is a question for Bob or in general. Because of its distance, I would never see, and plus it didn't exist there, when I moved in. I couldn't see how it would be necessary for residential traffic on that road. It was never meant to be part of the home, access to the home or egress from the home. So, which is interesting because of the way you were defining, you were saying will only be used for residential access, but there is a residential road to the home, which I've been to, and it's a lovely home. But this is much further away, so I'm just wondering that road's use for residential being so far away from the home.
The agreement definitely limits the use of either one to residential traffic. Also, the entrance you're referring to, which is very close to the museum, is there also for emergency access during his events. So there will be no questions about the ambulance or fire truck being able to go down Barton Road to his museum to support whatever emergency there may be. It's not there for users of the museum or tanks or whatever to use. It's there for emergency, and also he can use it for his own residential use for his house. Both. Yeah, both.
Hi, Wes Fisher. My understanding is there was an ancient path that ran from Barton Road to the river that allowed anyone from the public to walk that ancient path to view the Assabet. Does that go away now?
There's not a public easement. There's a private easement there, and it's documented on his drawings. But we've never made aware during our hearings that there was any cart path or public right-of-way to the river.
The Sunset Pathway is maintained, and it's being maintained through the construction period. It will be maintained after the construction's done.
And even there on the Sunset, whatever it is, drive or whatever, it's not very well defined in certain areas. So, but through Collings land, it is defined. He's got a driveway there.
So just clarification that public, it never existed.
It's never been documented. It's never been brought up to the planning board. And, you know, we've gone through 2 different developments on his site. He at one time proposed a subdivision development, and it didn't come up then. We were in that development going to provide a public access to some of the wetland areas and closer to the river through that property, but that was never finalized.
I think just to add something to Wes's point and the question, that Sunset Road is established road, Woods Road. To my knowledge, there's one person that has a agreed upon legal right-of-way to use it, which is Gerhardt and Cornell, because they have property that's landlocked by our property. Massachusetts law says you can always get to your property. I think your point, Wes, is that I don't think that's necessarily defined to be public access.
I'm still concerned about the definitions of major and minor as they concern the days. The major events, if they're 2-day events, and they're 4, that is a month of weekends that we can't use our property, essentially. And the minor ones, if your assumption is that they're 1 day, the pattern here has always been to expand so that it's potential that there are another 12 days that we will be impacted, and if they become 2-day events, that's 24 more days in addition. So it's an entire month that the neighborhood becomes subjected to this kind of noise.
I understand your concern, and I understand that you're pointing to a lack of specificity in the definition of minor event. So I'd like to make a broader point and then focus on that. The broader point is, the board, through negotiation, was able to agree with Mr. Collings to this number of events, the 4 major events. Absent this agreement, had this gone to court, to a trial and a decision by the judge, there might have been a decision that would allow literally unlimited events on the property. So I understand that from the point of view of the neighborhood, 4 events, 4 major events, 2-day events is a lot. We certainly understand that. But I think you have to look at what the alternative is here, and that's the point of the settlement agreement is you get some specificity, some limitations, because the alternative is unlimited use. And going back to your question about the sort of lack of specificity of a minor event, I agree it doesn't say 1 day, but we do know what a major event is. We do know that's a 2-day event. And if need be, with respect to any of these definitions, and then this also applies to the question about the definition of gunfire, whether that sufficiently regulates it. I'm a lawyer. I am very happy, if need be, to approach Mr. Collings' counsel, and if that doesn't resolve an issue, to go to court to enforce the agreement. That is the beauty of having an agreement endorsed by the court. It's enforceable, and judges understand what is reasonable, and I'm quite sure that if the court understands a major event is a 2-day event, a minor event cannot be equivalent to a 2-day or longer event. And I'm very happy to enforce that if need be, first with Mr. Collins' lawyer and then at the land court if need be.
I'm sorry to belabor this, but I might also point out that the event is not just when the gates are open and people come and observe. It involves preparation, and that involves days beforehand. Okay? So I hope that that's included in the, quote, major and minor event.
My impression is that the Second World War begins several days ahead of time when the crews start to come in with their equipment. And they have a good time on Thursday night, they have a good time on Friday night, and they have a good time through Monday. There were shots this late, or firings of various things that we could hear at our house, which is quite a distance, as late as 10 o'clock. On Sunday and Monday night. And that's not, to me, a 2-day event.
I don't have a lot of comment about your statement, except certainly we did discuss from major events that there was preparation included in that. Granted, we did not define specifically what that prep included. I don't know if you have any other comment.
I think, again, you just have to look to what the alternative is, which is a total lack of control over what takes place on the property. I can tell you that if it is really unreasonable, if it starts to last, as you suggest, to take place over many days, you can bring that to the building commissioner, and the building commissioner and the town can decide whether it thinks this is something that needs to be brought to the point of enforcement. I mean, that is always a possibility here, and again, that's why it's good to have an agreement that's enforceable by the court.
I was wondering if we could go back to the slide that talks about the major events, please. So, my understanding right now, we have Well, we have 3 major events, and they were discussed ad nauseum during the planning board process. And one thing that so I understand that in October there's the war for the battlefield or whatever fictitious event that is. My understanding is that, well, at least when we were discussing with the health department, there wasn't this difference between pyrotechnics and gunfire. Because the gunfire is blanks, which requires requires the snap, basically. So what I'm wondering, and so my first question is that currently he has one pyrotechnic / gunfire event, which is the reenactment or the war thing. But the other events, there's limited, if any, gunfire. And one of my major concerns about the October event is, you're just having many rounds of gunfire getting shot off and exploding over the lake, and that's a major noise event. And I'm just wondering why, like how I read this is that now there's 4 major events and all 4 of them have machine gun fire, and that's available. Is that, am I misunderstanding something?
Well, there is a distinction between pyrotechnics and gunfire, and machine guns would most likely come under gunfire. But the agreement limits the pyrotechnics to 2 events, and gunfire can be on the 2 other events. But again, to reiterate the point that was made by legal counsel, these are being limited. Had we gone to court and had a full judicial decision, we might have ended up with many more events involving much more pyrotechnics and much more gunfire. So this is a way to try to limit and contain those kinds of events as best we can. It's, may not be ideal, but at least we have some limitation. And as Barbara pointed out, we also have an enforcement mechanism. So if there's something that's going on that isn't meeting, the standards of this agreement, we have 3 recourses. We have the building inspector, we have the police, and we have the court to go and get an injunction. So I think those are our backup protectors, in terms of anything more expansive.
I just don't understand why we included gunfire on all 4 events when that wasn't something that was included previously. Like the race for the century is just horses and nobody shoots any guns. And other than the plane noise, it's a relatively quiet event. And the October event is not.
I'm sure that his race of the century will stay that way without his guns and everything. He's defined one new one, and I believe that new one, he might have a different idea now, but it was something pre-World War I, like the Civil War or Revolutionary War event. And he's got 2 events. He can have pyrotechnics and cannons. They make noise. The other events, he can have gunfire, but one of those events, if it's a race of the century, like you said, is without gunfire. So I doubt if he changes that, but he's the one that can answer that better than anybody else.
So there's no doubt that this represents a compromise. I think that's what you're hearing from both town council, from Lenny. And I do think the added event that did get added being pre-World War I, clearly that will limit the type of activity. And I'm not saying it's not going to be loud, but it's not going to be the same as the October event, just in the nature of World War II versus World War I.
Just a quick question. When during the 6-month period might this new event be scheduled? Is it a spring thing, a fall thing?
It could be any time. There may be a desire for a specific time of year. I think it takes a lot to coordinate these events, so I don't think the intention is to have back-to-back events. I don't think, quite frankly, they probably have the staff to do that, but so I think the idea was that it would be spaced out, but that's not specified that it's a requirement.
And if I could add, there's provisions in the agreement that Mr. Collings, the Collings Foundation, has to meet with the town, with town officials prior to the major events to work out public safety issues. So there are sort of notice provisions and a process put in place for to the parties to reach an agreement, to negotiate in good faith and reach an agreement on security and public safety measures.
Hi, can I just ask, you know, typically the events, I live right across from the exit to there, you know, the gunfire piece, it's like 15 minutes, you know, a couple times a day. So maybe, Bob, you could publicize during the events, like what time you're going to be doing the actual battle reenactment or the whatever 20 minutes of gunfire, so you know, those of us who have dogs can be aware. Perfect, because the reenactment piece isn't very long. I mean, okay, that's perfect. Thanks.
In case you didn't hear Bob, I believe he said 45 minutes. Just for everyone who, since you weren't speaking into microphone, Bob, I think I heard you say 45 minutes.
Katie's question was how long do the reenactments
Yes.
take place? We typically have 2 a day of 45 minutes.
So again, the answer to the question was 2 a day, 45 minutes.
A quick question. I don't know if this is for Bob or not. I've been to all 3 of the existing events, enjoyed them all. Other than for the very first event, it's a open house on Father's Day weekend, and other than the airplane rides, I would say that it falls into the minor events. It's just, you know, there is no pyrotechnics. The only intrusion for the neighborhood from where I live has been the vehicles driving to the event. And the airplanes, which, you know, sorry for all of you, most of my friends enjoy that. But if there's no airplanes because of horrible weather or whatever, it's, to me, it's a minor event. And so I guess my question is the event defined, like we're talking about these 3 events, when we talk about the major events, we're talking in this meeting and saying multiple times, well, he has these 3 events and then there's a 4th. And so, is the event defined in advance, or is this defined by what the event ends up being? Because I don't think that if there's no plane making more noise than the residential community, that it is a major event. It's a fairly minor event. Once the traffic is moved off of Barton Road, it becomes an open house, which is pretty straightforward.
Sure, you can certainly mention something. So I do want to clarify. When we started having the discussion of major event, clearly, again, I don't remember who asked the question to start. You know, we were going by what the major events were now. That doesn't mean that that precludes him from changing the event, but clearly the whole discussion was about allowing him to continue with the events that he has and then adding the 4th.
Yeah, I think as a point of clarification, the intention and the discussion with the planning board was the 3 current events are part of the 4 events. So Father's Day weekend, which involves no gunfire or anything, it's cars, that would be one of the events. The Race of the Century, which should be a second event. That doesn't involve any gunfire and so forth. Third event, which we currently have, World War II reenactment, involves noise. We are looking at leaving ourselves 1/4 option, and the idea there would be a Revolutionary War, perhaps a Civil War reenactment, and that's the reason for having a second pyrotechnic event, one pre-war, World War I era, so it would be allowing us to do a Civil War or Revolutionary War, and the only pyrotechnics there is basically an occasional very small cannon compared, no tanks and so forth.
So the question is, does that mean Father's Day and Race for the Century remain as is with no gunfire? And Bob basically just answered that that was his intention.
I have a quick question on, I know we're talking about the noise and access, et cetera. Oh, louder? I'm sorry. Just on a different topic as far as the visuals of the proposed museum. Mr. Collings, I was wondering whether the image that's been posted, I believe it was on Stowe's site, as far as the facade, is the appearance of the facade and its resemblance to the main building of Auschwitz. Was that intentional?
The question was whether the resemblance of the front facade, the resemblance to Auschwitz, was intentional.
Yeah. Absolutely not, and in fact, the front facade we are altering so it'll have 3 barn doors, so it'll look more like a stable. But there was no intention to look like Auschwitz, absolutely none.
Thank you. I was frightened when I saw it, and I thought, oh my goodness. So thank you for altering
Hi.
the facade.
On the permitted activities on page 4, there's display and management of artifacts and related functions. And under there's practical experiences. What does that mean, actually? Practical experiences, things that you can do that are as part of the day-to-day operation of the museum.
The Collings Foundation from 1977's mission is living history. It's practical experiences. It could be practical experiences with a sleigh ride. It could be practical experiences with so it's a broad term. And so it's generally historic practical experiences. But it's the idea is to experience these artifacts.
Does that involve driving?
Yes, it can involve driving a car, it can involve driving a tank, it can involve pulling a sleigh. It can involve any of the aspects of the artifact if it's an animated artifact.
Is there a dividing line between like the minor events and it could be like some of that might involve some noise making?
Well, there are noise limitations that differ between the major events and the minor events, and maybe the town council want to answer these. But basically, the idea is that the minor events do not cause noise generation beyond what is seen in the neighborhood. So the idea is they are outdoor events. Now, all of these are outdoor events. They're outdoor events. We might have the equipment out and running it and so forth, but again, no gunfire, no disruption, and so forth is the intention of those.
So that part of the agreement that mentions practical experience, that is a use that is allowed on the property, not as a matter of major or minor event, but that's part of the museum activities. But any activity that's a part of that is subject to the same noise, limitations that anyone else would have on their property that's enforceable through the police powers. So those events, they are, may not be specified, but they're subject to the same limits that anybody would be subject to on their property.
Are we to understand that the museum is open for 6 months only?
Yes. That was specified in the original application.
So just wanted to clarify, on one of your slides at the beginning said about once the road was open, there'd be no commercial traffic on Barton Road, but that other 6 months, what's going to happen? Because the road is not, usable in the winter, the access road. So if there are commercial things going on or whatever, they'll be using Barton Road, right?
That is not what's specified in the settlement. The settlement is that all commercial traffic would happen from the Hudson access.
So you're saying the museum is closed for 6 months, like he can't bring in commercial supplies or anything during that time? No, he can't. Because it says Hudson doesn't allow de-icing and salting on the access road, so technically that makes it not open safely for him to do stuff.
If there's no snow, I suppose they could still use it.
So I did one more question about, on the major events, is there any limitation on number of vehicles or people to be allowed at an event? Because, if you have 10,000 people in there, it's going to be pretty crazy.
Like any other large event that would be held in the town, it's subject to, police oversight, and in addition to that, it's specified in here that that Mr. Collings has to meet with the town to work out an agreement prior for, safety, for public safety measures to be in place. So if in the opinion of, the building inspector or the police, there needed to be a limit on the number of people assembling or the number of vehicles allowed onto the property, then those would be enforced the same way they would in any other large event. So no, there is no specific limit in the agreement, but these are subject to the same public safety measures that would be taken with respect to anybody, including the town, who wanted to hold a large event on a property.
I think because of some of the questions that have been asked or talked about regarding noise specifications, based on how I read this, and it makes perfect sense because there's really the only way you can measure it, the restrictions are based on noise levels, not the noise that you're hearing, which means if you hear tanks being driven in on the property, that it, that seems like it's not part of, the event that it should be labeled as. It has nothing to do with the fact that you're hearing tanks. It's what is the level of the noise that you're hearing. And noise specifications uses as examples motorcycles, leaf blowers, lawnmowers. I will tell you there are a lot of leaf blowers that annoy me in the fall. But hearing, I don't want to start hearing in the neighborhood, I hear the tanks, we've got to contact somebody. If, according to the way this is written, it's the noise levels, and if the noise levels is not as loud as a leaf blower, then that's okay. Is that true?
Your interpretation is correct in the sense that we're not saying there will be no noise. The way it's written says that the intent, the idea is that the noise would be within the nature of noise in a given neighborhood. There are certainly measures and steps if people feel like it is gone beyond that to take. And again, it starts with the building inspector, the police, and it eventually can be taken back to the court. So.
Does the town incur any costs associated with these events, either major or minor, in terms of policing, or is the town liable in any way for any accidents, and this includes to the residents in the area, as a result of these events?
So in the past, there have been agreements in place between Mr. Collings and the town that address these and other concerns, and the agreement calls for that practice to continue. And there is I think it's stated in there in the past that there is, a detail at the Collings Foundation's expense. So that is not an expense that is borne by the town. There is an indemnification provision in there so that the town does not incur any liability. There isn't anything specific to third parties, that is for property owners. I don't think the town can contract, can enter into a contract about other property owners. But if your concern is that the town is not sort of protecting the town's interest, I can tell you that hasn't been the case in the past. And the agreement provides that in an enforceable way, the town will continue to put an agreement in place that does protect the town against those expenses.
So I understand that a compromise has been reached here. I'd like to speak on behalf of a couple of people. One, Tom French, who's deceased, and questioned whether this was a nonprofit or not. The other person is Thoreau, who I think he'd have a different feeling about what's happening to Lake Boone. You lie on your back and get educated by cannon fire. I don't think Thoreau would have liked that.
Just a quick question. Is the construction, from what I quickly read was daylight hours, is the construction restricted to weekdays or any day of the week during daylight hours?
I believe the construction is under the same as any other building project in town, which I believe is 6 days a week, although different hours on Saturdays than weekdays. That's town-wide, any building project. So we did not specify anything different for this. Right. So basically, same hours as any building project in town. And again, I know we heard some concerns tonight, which we'll be taking up with the building inspector, but no specifics called out in the agreement that are different than normal building projects.
Question about the road construction from Hudson. You mentioned that Hudson imposed a 90-day construction, imposed by Hudson. When does that clock start? And as a follow-up, You mentioned that the museum construction will be over the winter. Does that imply that the road from Hudson will be used for the construction of the museum over the winter?
Yep, no, that's okay. I think the question was whether or not if the project is going to be, the road's going to be constructed over the winter, would the vehicles doing that construction during the winter be using the Hudson access?
Well, the limit on the road construction is 90 days for the construction of the road. It started. And there was a question earlier about why did we not start in Hudson. Well, we virtually started in Hudson and Stowe simultaneously because it is quite a large project. So we're not favoring one over the other. We're just trying to get the job done so we then can bring in more of the construction equipment and also the traffic for the World War II reenactment, which is October. So our date to get the road done is before October. Yeah, over the winter there will be traffic of contractors and things coming in because the anticipated plan is the building will be up by around December, closed in, and then during the winter you have your trades, the electricians, the plumbers, and so forth, finishing the building out, and then you have it ready hopefully in the summertime, around June or July.
I'm sorry, but what are the 6 months that it's open, and what are the 6 months that it's closed? Or are they variable?
I don't recall. April through October.
Is it 6 months or not?
Yeah, that's 7. Again, it's the months were stated in the application. I don't know them off the top of my head.
Mm-hmm.
6 months is May, June, July, August, September, October. And the reason being closed in the winter is generally it's a much slower period for museums. We're not planning on heating the museum. It's quite a large building, other than to about 45 degrees. And so it's just kind of an anticipation of limited interest in the museum, particularly in the wintertime. So that's the reason why we designed the building not to particularly have the heat load that we would need to have for a large building in New England.
I'm just a little bit confused, and I wanted to hear it said very clearly. It's been stated that the construction would go on during the winter for the museum. So I would like to hear very clearly that none of that construction vehicles or materials will go over Barton Road, that is all going to be, even though we're talking about the road being closed during the winter, if winter construction happens on the museum, then all that construction traffic will be using the entrance from Hudson Road and not using Barton Road at all.
We would anticipate that all of the heavy construction vehicles would be done at that point in time. There may be plumbers or electricians or other that have more conventional vehicles. And by the way, residential use includes UPS and FedEx and deliveries with Staples and other kinds of things. So when we talk about residential use as opposed to commercial use, that doesn't mean we can't have our trash picked up. That's a residential use.
Which is that the final, the building permit for this hasn't issued yet, and the building inspector, in consultation with the town, can place the same sorts of conditions on the construction that it did, that he did in the building permit that was issued. So I would just say that's, that's a matter that we do have control over.
So the question is there any idea when the agreement would be formally accepted by the court?
So it's been submitted to the court, it's before the judge, and unfortunately, I just don't know. We've communicated as best we can with the court, and they know that we're waiting for the court's decision, but unfortunately, I can't give you a time frame.
And correct me if I'm wrong, Barbara, but I also believe that the judge, number one, knows that there's an agreement and knows basically the basis of the agreement.
Right. Lori makes a good point, which is that a few months ago, we were in land court before Judge Long and showed him what was essentially the final version of the agreement that you see. And he looked through it, he understands the issues. I'm not saying that he understood everything that was in it, but he's aware of the process that the board undertook and the selectmen in reaching the agreement. So he actually made a suggestion at that time, something he thought needed to be a bit clearer, and so we did revise the agreement to reflect that. So I think he understands the nature of the agreement.
Just one further input to that, and Barbara, correct me if I'm wrong, we have received notification from the judge's clerk that your judge has approved it, but he hasn't signed it.
Well, I haven't heard that either from the judge's sessions clerk or anyone else at the court, so I'm not sure where that comes from, but until I hear from the court that it's been approved, I can't sign on to that.
That being said, and you can correct me if I'm wrong, I think we both are anticipating that it will be accepted. So I don't want to give anybody the impression.
We don't interpret the absence of approval by the judge as a negative view by him of this process or of the agreement. It's just part of the court's process. You really have to wait for them. So it's not that I see any problem. I just get a little nervous when I hear about something that I haven't actually eyeballed. So I think Lori was correct to supplement my comments, and I would agree with her that it's we have no reason to think it won't be approved.
All right, I guess we're winding down. I'm going to thank everyone for coming out. I know this process hasn't been easy for anybody, and it's been long. And I'll be around for a few minutes if people want to chat as well. So thank you.
Every building looks like that.